Good morning, everyone. Today is Tuesday, October 13th. Thank you for joining us. I'm Joanne Koontz. I'm here with my partner, Jackie Durham. And our lovely guest of the day is Whitney Harper from ADVOS Legal, who has been an amazing find for us. So welcome, Whitney. Thank you for joining us again.
Absolutely. Glad to be here. Thanks for having me.
She's always willing to share her information and her spectacular one-liners. I kind of felt like I had the monopoly on one-liners, and I feel like I've got a sparring partner now. So, sometimes the girls here are like, "Where did you come up with that?" But you know, you got to have something to keep it fun. So today, what we wanted to talk to you about was the difference between independent contractors and employees. Whitney's firm and our firm, as you know, both work routinely with business clients, and we work more with folks that are just kind of getting out of the gate. Her folks are a little bit further in the life cycle of the business typically, but I think both of our clients run into the same questions and same concerns when it comes to independent contractors. I frequently have people say, I have an employee, she's this, but she's 1099. Well, you don't have an employee on 1099, hopefully, because if so, you're going to have some trouble that Whitney's going to tell us about. I also will hear people say things like they're paying someone either W-2 or 1099 because that's what the person asked for. So that was their request. We're going to get to why that's not the best way to to do things. So Jackie and I will pipe in. We'll let Whitney take the stage. And if you guys have questions at any time, you can always enter them in the Q&A box at the bottom. As always, our webinars are recorded and will be distributed to you by email. They'll be available on our YouTube pages and on our Facebook pages and on our firm websites, KoontzAssociates.com and KoontzParkin.com. And I'm sure ADVOSLegal.com is going to be sharing them with you as well. So
Know it.
All right. So Whitney, tell us the good, the bad, the ugly.
No doubt. Well, so first, let me just say, I am terrible when I get on a tear about a topic that I'm interested in, and this is one of them. I am terrible at watching the chat and questions. So if you,
I'll do that for you. I will interrupt you as appropriate.
I hate to miss people's questions, but I get laser focused and I forget. So your comment about the 1099 employee is one of my very favorite things because it is like Sasquatch, right? Like it does not exist.
Yeah.
And yet people talk about it all. Like we have documentaries about Sasquatch and we have employers talking about 1099 employees all the time.
Fortunately, no documentaries yet about that.
Yeah.
Coming on Netflix, I promise.
Yeah, and we talk about this like it's the hunt for the 1099 employee, like a hunt for Sasquatch, right? And how to stay off the crosshairs, because it's one of those things that I think business owners in particular tend to hear a thing from a colleague and take it as the gospel as to how this 1099 versus employee thing works, and really like cling on to some things like, oh, hey, the person asked for it. Or one we're hearing a lot right now with people going to work from home or working in different sort of more flexible situations is, oh, well, now that they're not in the office or now that they have flexible work hours, they're an independent contractor. I'm gonna move them to 1099. And that sort of like fundamental but incorrect belief that because someone has some flexibility, they are properly classified as a 1099 is something that can get employers in a whole bunch of hot water. And so, our job is to help kind of keep that from happening, but also to equip our clients with some really good, just kind of baseline level decisional factors, right? So helping our clients to understand, like, what are the three key things that if I know those, and I kind of look out for those, I'm 80% likely to get it right, right? And you guys practice that way. That's a big part of how we work, is just understanding that every decision in business carries some risk, that, you could have the perfect contract at the risk of not getting anyone to sign it, right? So like there are risks and rewards all over this business. And we want our clients to be able to make heads up decisions about those risks and then kind of go forth, right? So I think the idea today is just to kind of give our clients and the attendees a sense of what the differences between an independent contractor and an employee are, why those differences matter, like who's watching and what are the risks of getting it wrong, and then kind of a feel for how to make those decisions, how to make that call. And then, once you've made a decision, I think it's also important just to know what you can do to further protect yourself from the risks around that. So I think we'll talk about all of those things today.
Absolutely.
As I think about kind of the top level, like, why does this matter question? There are a lot of agencies and a lot of folks out there who care a lot about whether you get this right or wrong. And so anytime you have something where there are agencies with lots of letters involved, right? When you get alphabet soup kind of watching you,
yeah,
I think that's when you know that there are some potential consequences that could be very real. And so some of them, right, are right up your alley, right? The tax consequences of getting this wrong. Yeah. Some of them are more sort of straightforward, what you might expect, like wage and hour claims and that sort of thing. So let's think about it, just kind of run down the list of who all cares and why. The Department of Labor cares a lot about making sure that your employees are properly classified as employees, that employees are getting paid at least minimum wage, that they're getting paid overtime if they're not exempt from overtime, that they're being provided benefits that are appropriate and that are within the kind of the bounds of and requirements of the law. And even things like making sure that people have the protections of the ADA and the FMLA, right? So independent contractors don't get the protections of the ADA, which means reasonable accommodations for disabilities, or Family Medical Leave Act, protections of that sort. Nor are they going to have the same protections as employees around discrimination and retaliation. All of those things matter a lot to the Department of Labor and the EEOC. Those pieces kind of fall really in the employment law side. And the other part that's interesting there is we're also seeing rulings where someone says, hey, I've got 10 employees and 40 independent contractors, and there's a determination that those independent contractors should have been employees. Well, now a whole bunch of employment laws that would not have applied to you because you had such a small employee base actually do apply. And so the things where there's a number of employees that kick you over into a compliance requirement can really be triggered by this if you get it wrong. The other side of it is, and I think actually this, to my mind, this is the more immediate risk because it's about somebody who sees you with their money in your pocket and they want to come after it. And that is IRS, state taxing authorities, those folks who are very interested in collecting their payroll taxes. So I don't know if you want to chime in on that part.
Yeah, they absolutely are very interested in that. And they love to hear from disgruntled former employees or potentially disgruntled future ex-spouses. So it's not even just that somebody's going to knock on the door and find you out. You do see that, especially you can talk about the Department of Labor and their pet industries like construction, where they like to just show up unannounced and cause all sorts of havoc. But with the IRS and Department of Revenue or whoever else you're involved with on a state level, those folks get wind of things in different manners. The penalties are different, and more importantly, the tests are different. So you may be properly categorizing somebody for IRS purposes, but you may have a factor under the Department of Labor test that actually turns them from independent contractor to employee or vice versa. So you cannot operate in a silo, which is my mantra. Marina loves the devil's in the details. And I'm like, My favorite one-liner of Whitney Harper in my whole life is, "Don't make me look in a dark room with a flashlight." And this is the same thing. When you approach your business from that method where you're like, okay, well, the IRS rules say, and that's all you're worried about, you have your own flashlight. And that's worse than when I have a flashlight. Because I at least know what I'm looking for.
It's a really interesting and frankly confusing minefield for employers. Because to your point, none of these agencies uses the same test. Even to the extent that they use the same factors, they define them differently and they weigh them differently. Like, it's nuts. It's absolutely nuts. And if you think about it just from kind of the common law perspective, what is an employee, right? It's a really broad definition. So the common law concept of employee it's broad and disheartening. It's someone who has suffered or permitted to work in the business, right? To suffer or permit feels like work, right?
I'm definitely suffering here today.
So if from that perspective, right, you would almost say, well, anyone who does anything in my business is an employee. And certainly if we're talking about a spectrum of risk, that is the most conservative approach and the one that's not going to get you in any trouble. If you just say, hey, you do work in my business, you're an employee, great. However, you're still going to run into shades of gray where you might have someone like an outside service provider who is legitimately not an employee, right? So the other side of that spectrum would be things like your firm and mine, right? We are service providers, and yet it is also possible for us to perform our functions as employees of the business. So in that regard, you have these kind of two ends of the spectrum where you still could see some gray, right? What if instead of a law firm with several people in it and some kind of real mechanisms of business, what if I was Whitney Harper, PA? And I had hung a shingle, but I was really only serving one client and really like working in their business, not outside as a service provider. Well, now we get more gray, right? Even if my client's business is construction and I'm a law firm, right? So no matter how, how you'd like to say it is cut and dried, it's really not.
And the risk of being wrong is immense.
Yes.
Financially.
Yes, I mean, you have big financial risks, right? So you have the wage and hour issues, the tax issues, all of those pieces. You also have the legal risk of someone bringing a claim that you have failed to comply with worker protection laws. And then you have things like, I mean, even we talked about all the discrimination stuff, but workers' compensation, a hook for that. And so now you're going to have someone who may be bringing a claim that they're an employee because now they've got medical bills that they need you to cover. And so there's a whole bunch of different risks here that some of them are never going to show up until they show up in a big way, right? The work comp claim doesn't show up until somebody gets real hurt, and now you're in the crosshairs. So you want to think through where, how much risk am I willing to take on here, and what's the reward for it? And just so you've heard some of the names of the tests, if these come up. So I think everybody likes to know sort of what's being talked about, right? If they hear it being bandied about, even though I will tell you that 99% of even the lawyers who do this could not rattle off what are the elements of these tests. You have things like the economic realities test, a control test, which is also called a 20-factor test. Real easy to apply, 20 factors. Thank you for that, IRS.
What could possibly go wrong?
Yeah. There's a common law test called the Darden test. And then the Department of Labor is proposing a new test to come out. So, I mean, there's, it's
that'll fix it.
Yeah, sure. Yeah, absolutely. So you've got all these tests, and if you think about kind of what are the commonalities, right? They all are balancing tests. So In none of these instances is there a single factor where if you check that box, you're safe.
Mm-hmm. Or dead.
Terrible, right? There is no like clear check the box and you're good. They all have a factor in them around control. And they're looking, what I mean by that is looking at the degree to which the company has control over the manner and means by which the worker accomplishes their work. Most of them look at whether the thing that the worker does is core to the business. So in my example earlier, as a law firm, if I were providing my services to a construction company, my services probably aren't core to the business. Mm-hmm. However, if I'm a single independent contractor lawyer providing my services to a law firm, much more likely to be core to the business, right? They also look at permanency of the relationship. So is this I just need a project done, or I need a specific kind of period of time handled? Or is this a forever and ever amen kind of deal? Mm-hmm. They want to think about facilities and equipment, right? So who's providing the stuff you need to do your work? Although that one is shifting a little in some of the tests that we see. So that used to be a sort of almost dispositive sort of factor, and that's beginning to shift a little. A big one is whether this independent contractor offers what they do to the market as a business, right? Are they advertising? Mm-hmm. Are they out there available for someone else to engage them as well? And here's an interesting negative commonality. None of them care what you or the employee say about what the relationship is. Right. Not a one. They do not care. They don't care what tax form you use, and they don't care what the common industry practice is. And that's a big one, mm-hmm. because we hear a lot of people say, oh, but all fill in the blank people get paid that way. Everybody in this industry who does that role gets paid that way.
Oh yeah.
And it's a little bit of the, like, they just borrow one from your mom, right? If everyone else jumped off the bridge, would you too? Mm-hmm. Because they're all jumping off a bridge, right? That's what they're doing. And they've taken some measured risk with it.
And a lot of times people don't know. For us, people are starting a business and maybe they were a lawyer at a law firm and now they've gone on their own. Maybe they were the project manager for a construction company and they've gone out on their own. So they're drawing from their experience from when they were an employee or independent contractor and saying, well, this is, I get it where people come in and they're like, this is the contract that my company before was using. Can you help me use it in my new company?
Yes.
Whoa.
So, it's interesting because I think there's a lot of areas in business where as long as both parties agree that here's the story we're selling, like it's fine, it's legal, it's like it works as long as both parties agree and contract for it, right? This is not that. So this is one where if you've got it wrong, you've got it wrong, and you can both be wrong, and that's not going to save you. So just really important to kind of think through all of those pieces as you evaluate whether someone should be a contractor or an employee. So if you think about really a contractor versus an employee, going back to that two ends of the spectrum, right? An employee is somebody who you're telling what you want done, how you want it done, when you want it done. You are determining their compensation, and the shade on that one, right? Determining compensation. As an employer, I figure out how much I'm going to pay someone for the role, period. I also determine how I'm going to pay an independent contractor, like an outside service provider, right? Because that person sets prices and I either buy or don't buy at that price, or we negotiate a price. But the leverage is different, right? It's a negotiation more than the law and the agencies would characterize an employee-employer relationship on the pay front. Mm-hmm. So employer has lots of control, controls the money, is telling you what to do, when to do it, how to do it. On the other hand, a true independent contractor, I would suggest you take independent contractor and get rid of that word, that phrase, and instead think vendor.
Mm-hmm. Yep.
Right? Service provider, vendor. Even like consultant, if it's someone who truly offers consulting to the market and you are taking them up on that offer for some piece of your business. But if you have a role and you're thinking, I can either get an independent contractor or an employee to fill it, your antenna should go up. And it's not to say that they should always be an employee, but those are the roles where you want to be like really thinking through it well, because if it can be one or the other, there's risk involved.
Mm-hmm. Right.
Sure.
And I feel like there's, I've noticed clients who have gotten into some trouble with that. Typically, to keep things easy, they have sometimes the consultants or the independent contractors, because that's what it says in the contract, submit timesheets. They're paid on the same day that their employees are paid. They're walking and talking like an employee. And I would you agree that it's probably good practice to make the independent contractor invoice you to try to establish what the parameters are for the total cost of the project up front? And I also think that establishing a deadline is obviously important to a project, but making sure that their hours are flexible within, when they choose to complete the project, as long as they meet that deadline.
Yeah, those things are really important, and very good points. One of the tests talks about is the person paid hourly or are they paid for the output, right? And I think that's a tough one, because there certainly are independent contractors who are truly independent contractors, but who invoice by the hour, right? And frankly, most law firms are a really good example of that, right? Mm-hmm. Classic bill by the hour. And that doesn't necessarily, again, nothing's dispositive, right? So it doesn't necessarily mean, you're not an independent contractor if you're billing by the hour. However, one of the ways that you take an hourly billing arrangement and you make it clear, or more clear at least, that this is really an independent contractor is, to your point, doing it on an invoice, as opposed to I'm logging into the same system that your hourly employees log into and logging time that way. And I'm getting paid through a payroll process versus I'm getting paid based on submitting invoices. Again, you're characterizing what we have as an independent contractor as a service provider who runs a business, who is a vendor to the company, versus I'm an employee and I'm part of your workforce. So I think turning a critical eye to those things can be really, really helpful to business owners who are trying to figure that out, for sure.
Right.
Yeah. One of the things that you mentioned earlier, I think, Joanne, it was you, who was talking about when the employee asks for more flexibility or wants to set their own hours, right? Does that mean that they're a 1099 contractor? No. Just no, it doesn't. And it's really interesting, I think, because there are so many businesses right now that are shifting the way that we work, right? Everybody's going remote. Things have gotten more flexible out of necessity because we're all trying to juggle children and home and work and do it all at the same time in the same place without, like, the bounds of an office. And those things have certainly bubbled those issues up. But again, unless you are also shifting the way that person provides services to you with respect to the control that you have over the outcome and the method of how they do it, and who's providing the equipment and who's directing the work, and really, like, if it's still core to your business, then you really need to keep them on as employees, because that is a very risky proposition when we see people take someone who presumably the employer had decided they were properly an employee before. And now we just shift the flexibility factor, not the control, not the core, just the flexibility. And we shift that one and we say, okay, now you're a contractor. We're sending up red flags, right? There's nothing about that person's role other than the hours in which they do it or the place from which they do it that is shifted, that would kind of kick you to the other side of that range. So I think that's one that is really important for employers to be aware of, that lack of consistency can cause some really big problems, you know? The other one I see that's a big red flag to me is a company that says, you're a contractor because I want to pay you solely for production, right? So think about, I have commissioned salespeople and I'm not going to pay them a base. I'm going to keep them hungry and I'm going to just pay them commissions. Okay. So are they offering them their services out to the market at large, which some do, right? There are properly classified independent contractor salespeople out there who sell lots of different people's products and that's what they're up to, right? Totally fine. However, if this person is a sort of a captive salesperson to your business and you're telling them, here's how you sell, here's what you sell, here's when you sell, the only thing different from an employee being, I don't want to pay you a base pay, you're going to run yourself into some problems, and they're going to be myriad problems, in large part, and I don't mean this as a negative stereotype, your commissioned salespeople are very much driven by money, right? That is why they are commissioned salespeople. They're great at their job. And the minute they think they're being taken advantage of on the money side, they are going to send up alarms, right? And so
they are noisy.
You've just bought yourself a whole bag of problems with that.
The other thing to what you're saying too is that I see people who say, well, I was going to hire Whitney and I was going to make her an employee, but she told me she needs the write-off, so she would prefer to be an independent contractor. So she wants to be paid 1099 because that's what so that's why we're doing that. Yeah.
Yeah. We hear that all the time. And very frequently my answer is, if Dear Whitney would like some write-offs, Dear Whitney can go set up her own LLC and find some consulting gigs and do that. But you got to make good decisions for your business.
Exactly.
And so the business owner needs to make some informed decisions about risk, right?
But it's amazing how much that's out there. That is like the legitimate conversation. It's like, well, that's what she needs. Yeah. Okay. And the employer is like telling me how excited they are because she was willing to take $20,000 less a year because of it. And it's like, whoa.
Yeah.
Wait a minute.
What's even better is when the CPAs are offering the legal advice and they pull out I forget off the top of my head the number of the form that you can use to weigh whether or not for tax purposes someone is an independent contractor versus an employee, and the CPA is like, here, you're fine, you're totally fine, this person could be an independent contractor. Because to your point, Whitney, there's different tests based on who you're asking, and just because you might qualify as an independent contractor with IRS doesn't mean the Department of Labor will view that same, and they don't care about that form.
Correct. So.
And their penalties and fines are much stiffer even than the IRS. Because here's the thing about the IRS is the IRS cares a little bit less, because if they're 1099, they're getting the payroll tax from that person, from Whitney. They're not getting half from me and half from Whitney. So they're still whole, so they care less than the Department of Labor cares, because there's at least some financial parity there.
Yes. Yeah, I think it's a really good point. I always try to kind of distill it down to a handful of kind of guiding principles. So as I run through this with our clients, and I would imagine that your analysis is pretty similar to this with your clients. If I had to say, what are the 3 things that I want my clients to be equipped to think about without having to call me? Yes, call me if you want to. But if you want to be able to make good decisions on the fly, and at least have a good barometer for, is this one problematic or am I pretty safe? The three things that I would think about is this person offering their services as a business to the public? Do you control the way they do the work or just the outcome, right? Are you buying a deliverable or are you telling them what to do and how to do it? And is the work core to your business? So if the thing that you sell to the public is also the thing that that person does, or that person is producing or working around in your business, you likely have a problem if you want to call them a contractor. So those are my three kind of just gut reaction, like where do you stand on those? If any of those throws up a flag, then I would suggest pick up the phone and you call your counsel. So in the order of sort of how do I protect myself, right? There's 5 things, and because it's cheesy, they're all 5 C's, right? So counsel, have a really clear conversation with your counsel. You want that conversation to be privileged, right? This is not I ran it through my CEO group kind of question. This is privileged conversation because you need to be able to be totally straight about it, right? This is not like, well, I can make the argument that they go this way. Like, open the kimono, tell your lawyer, here's what they're doing, here's how I'm working with them, here's how I'm paying them, like all the things, and just lay it out there, because there may be some ways that you can shift some of those kind of factors in your favor and reduce the risk. But you can only do that if your lawyer has a really good understanding of what's really going on, what are they doing, how does that fit in with your business, all those pieces. So first one is counsel. Second one, caution. So err on the side of characterizing them as an employee, right? That is, if you've got someone who you're like, it could go either way, fall on the employee side of that fence. Contract. So this is really important, and for several different reasons. If they are going to be characterized as an independent contractor, put a contract in place, right? It's right there in the name. Let's do it. So independent contractor is not just about how you report their income on a 1099 or a W-2. You want a contract because you want to sort of tell the story in your own words, right? We know that the agencies aren't going to give a whole lot of weight to how you characterize it, but you can put some stuff in writing that can be really helpful. So get a contract in place for that reason. But also, you want to protect the confidentiality of your key information. It is likely that your independent contractors are going to have access to really important information about your business, and they're not your employees. And so if you want to be able to assert either with that independent contractor or to other parties that information should be protected as confidential, you better have an agreement between you and your contractors that treats it as confidential, right? Don't erode your arguments elsewhere because you were kind of slacking off with respect to this relationship. The third reason that you want a contract, though, and a lot of business owners are unaware of this one, it's so counterintuitive. If you have an independent contractor who is creating intellectual property for you, you don't own it unless you have a contract in place that says you do. So the part where you engage me to create something for you and you're paying me for that deliverable does not automatically mean that you own the intellectual property behind it. And it's so backward, like that's just a brain breaker. And it just is what it is, but you need a contract that says you own that stuff. That becomes super important for businesses who later want to sell the business. If you want to sell your business, have an exit plan, create some value, you need to be able to tell the potential buyer that the thing that they think they're buying actually does reside in that business. The business owns that IP. And we've seen instances where somebody created something as a contractor. It was early days for the company and they didn't have a contract in place. And now they're trying to sell the business. And the buyer says, I need to know that the guy who created that has given you all the rights to it. And you go back to that guy and you say, I need you to sign this little IP assignment. And he holds out his hand and says, sure, take a check for that. Yep. Mm-hmm. Don't be held hostage later. Just get it in writing. It's not that hard to do, but really, really important. So counsel, caution, contract, consistency. You want to be really consistent across roles. So for instance, we talked about somebody who now has some flexibility in their role and we want to make them a contractor because of that. If we have 10 other people in the business who are in the same role, who are characterized as employees, and we want to take this one person in that role and make them a contractor, we have a problem. So tell a consistent story across your business, and you will be much better off. And then clarity. And this one, it's sort of surprising to me that this one trips people up, but it really does. And I think for a lot of smaller and kind of growth stage businesses, it's because we all want to appear bigger than we are. And so when you have contractors who are out running around in the market, who have a business card with your company's name on it and a job title that sounds like they're an employee of your company, you have just created the opposite of clarity as to that person's role within your business. So just being really super clear and consistent with your internal and your external communications about who's an employee, who's a contractor. Don't muddy those lines and create a fact pattern that is bad for you.
And here's the thing, to your point about the contract, if you are memorializing the arrangement in the contract, it's going to give you the consistency and clarity, because you're going to start to identify, like, as your lawyer is writing it or as you're putting this together, you're going to see those trends where if you have this much, then it really does start to look like an employee where you're doing the wrong agreement. And then there's also no ability for everybody to get the lines blurred. So while those are important components, having that third component of the contract is going to help ensure that you stay consistent anyway, as like a byproduct of just doing the contract. So the exercise of getting that contract together, sometimes, even when we see it with operating agreements, like it's not really, the document is necessary and helpful and important, but the exercise of getting to the document sometimes ferrets out more issues to discuss.
Yeah, the document is the byproduct of the hard work to get there, right? In so many instances. And
so don't call us and ask us to spit it out by tomorrow morning, please. That's my least favorite call. I need this. It's really important and I need it tomorrow. Like, do I just make up the terms or did you want to tell me about them?
Yeah, I mean, it all starts with good, candid conversation with your counsel. And I think if you are having those conversations along the way, you're going to get ahead of those things, right? And business owner is going to be able to begin sorting through, how do I want to classify this person? How much risk am I willing to take here? What makes sense even from a use of my resources perspective, right? Mm-hmm. Is there enough risk here that spending lawyer dollars on it makes sense? Mm-hmm. And, where do I fall on that spectrum, right? Using my resources, risking my resources, all of those things. They're all really important decisions and conversations for business owners to have with the people who they trust around them. And those, that conversation then leads into each of those other pieces that can help you to put some padding around you, right? Bubble wrap is a good thing. We live in a risky world, and it's good to have the time to take those measures to help protect your business, which is, for most of us as business owners, right, that is one of our biggest assets. It's also one of our biggest potential liabilities, right? So little things like this shouldn't be the things that trip you up and take you down.
Right, and it's a small investment on the front end to really avoid a lot of liability and risk on the back end. I think it's so much better. It's business planning. Just like you do your tax planning, your financial planning, there's no reason why you shouldn't do your legal and business planning. So,
on that front, as we're in Q4, this is a really good opportunity for businesses who are listening to this and saying, oh, crap. I've got a whole bunch of people who are probably misclassified. How do I carefully extricate myself from that, right? How do I go about shifting them into a proper classification without sounding all the alarm bells and telling everyone to come running for back pay and whatever else, because I may not have been doing this correct up to now. We find that often a fiscal year or calendar year shift is a really opportune moment for a business to say, hey, one of our objectives in Q4 is to get all of the agreements put together and to maybe redo our compensation plans for the new year and think about how we're structuring the business, right? So you talk about it in broader terms. We're going to reorganize a little bit and shift some roles, right? But you want to be talking with your counsel along the way through Q4 to think about what are the things that I would want to be able to point to down the road if somebody came back and said, well, yeah, I was misclassified all those years, obviously, because now I'm an employee. And you couldn't have shifted me to an employee if I had properly been a contractor, right? What are the things that I would want in the new job description or in the new comp plan that would help to tell the story in a way that protects the business owner from risk, particularly when they're trying to do the right thing, right? When they're trying to make a decision, shift back toward what they now understand to be the more appropriate approach. So think about that through Q4 if you are sitting there going, I've got a problem, because those sort of annual shifts become a more natural transition point that just, they tend not to raise the alarms that kind of an off-cycle shift will do.
Absolutely. Absolutely. And we do have a question where someone is asking, Marcio is asking, consultants on a retainer contract are really like employees, as all projects come your way forever and you need to justify dedication and negotiate raises all the time. Not a chance to become an employee, but becoming exposed to occupational hazards. How best to handle this other than quitting? That's a loaded
yes. It's kind of interesting. And the first thing that comes to my mind is run it like a business, right? If you are a contractor and you like being a contractor and you want to stay a contractor, then run it like a business, right? And so that may mean that you need to recognize if you've got a customer concentration issue, right? If all of your revenue comes from one customer, they've got a lot of leverage and you've got a lot of risk. And so it may mean that you need to shift so that you have other sources of revenue, or sort of have a different conversation around that risk with your main and potentially only customer. Yeah, that is.
Yeah, beyond today, but the banks also don't like that concentration of risk either. So when you talk about running the business and doing it in a real way, that's when you have that, you are just creating future problems for down the road too. And people don't care today when it's new about financing, but
yeah, and it's interesting that there really is not a lot of risk for the improperly classified contractor, right? So that person really doesn't have like, okay, you've misclassified me. I might prefer to be classified differently, and so that's a conversation to have. But there's nobody coming after you about that, right? The Department of Labor is not coming after that worker. So the risk is really all in the engaging or employing company. And so that's where the pain point to my mind is. But yeah, I fully understand that customer concentration issue.
Yeah.
It's a scary one.
It is. It really is. So thank you for that. I feel like from the tax standpoint, we talked about it too, where the only real downside on the tax side, because yes, there is parity, the employer and the employee is contributing the self-employment tax. The only other risk there is that when you talk about the benefit for the contractor would have a benefit in the tax realm, because they may be able to deduct things that otherwise don't meet the threshold as unreimbursed employee business expenses. So if I was an employee, I've really got to get a pretty decent amount of expenses that are not reimbursed. And since the standard deduction has now doubled, that really practically puts a lot of people out who otherwise previously were able to make those deductions. So there was a shift when the Trump tax law went into place a couple of years ago for people to make this switch then to say, well, now I can't get those deductions on my tax return, particularly folks who legitimately, I had one guy who was in furniture sales, like medical office furniture sales, and he had to buy his samples. So they were expensive, but he legitimately had to buy them, and he was an employee. So those folks say, hey, I don't want to not write off this $6,000 piece of equipment that I'm trying to sell. So the only way to do that is switch me over so that I can be on Schedule C. And that's just because it feels, if my favorite business litigator, Michael France, says, if it feels good, you better not do it.
That's a good one.
He also has a fair amount of one-liners, but he's not wrong about that.
Great. Fun one-liners, but also just interesting problems to solve, right? I think that's one of my favorite things about practicing law and about questions like this is that there are real problems that matter to the functioning of the business. They matter to the way that people work. And I think they matter on a personal level, right? There's a whole bunch of emotional sort of concern in the employee versus contractor. Do I sort of, how much do you own me, right? Like, how much control do I have over my own life? How much agency do I have? Versus the traditional employer of like, I'm going to tell you what to do, and it's your job to show up and do what I tell you to do. And I think our workplaces are shifting in such an interesting way lately. Particularly, you think about gig economy and people who freelance so much more than they ever did, and the fact that I can work at any hour with a device that fits in my handbag, and do a webinar.
Yeah, that's true.
And all of those things have made it so much easier to blur the lines on these questions that traditionally were really cut and dry, right? I run a manufacturing plant. You show up on my line, like you're my employee, you can punch in and punch out, and I can tell if you're slacking because I can see that your hands are not moving. And it's so different for so many types of roles right now that these questions become really nuanced. And the law, sadly, is pretty slow to keep up. And so, in this case, I think it is an area where we're going to see a lot more debate. We're going to see court decisions that are going to be
all over the place.
Yeah, I mean, much tougher, right? I don't necessarily want to be a judge on this one, right?
The good news is I'm not fair or impartial, so there's no danger of being a judge.
No worry about that.
No.
I mean, I think we're going to see some really interesting rulings, and as those rulings are all coming down and legislation kind of slowly makes its roll through, and agencies move a little quicker than legislation does, at least in some cases, I think we're going to see some interesting, I don't know if relaxation of the rules is the right phrase. It's probably not relaxing. It's probably awakening.
An altering of the interpretation as the work from home environment you know, now it used to be different when you would say, well, if I email you in the evening, do I expect you to check it? Do I expect you? Well, maybe now I do, because you might be out during the day when you otherwise would have been working because you're doing kids' homework. So now maybe to expect you to reply at 8 o'clock at night is not, that may be your normal work hour now.
Right.
And I may not know that as the employer.
Yeah.
So I think all of that, you know, we used to hear though, if you tell them, if I email you, it's for my convenience, I'm not expecting you to reply. Well, that stuff's harder to do now.
It is.
When that might be someone's legitimate work hours. We have one quick question from Nermine. Are we required to provide workers' comp for independent contractors?
Interesting question. And so I will only speak to Florida, right? Lord knows what the answer is anywhere else. Generally speaking, no. I think there's some industries where you're going to have some tighter calls, right? But generally speaking, if someone truly is properly classified as an independent contractor, no, they don't get work comp coverage.
Right.
So
Perfect.
Are they really properly classified?
There you go.
Exactly.
There you go. Well, ladies, once again, amazing. Happy to have you, Whitney. Any final parting thoughts?
Oh man. No,
Call
I mean,
early.
always a pleasure. And I hope we get to do this again soon, because it is such fun to nerd out a little bit and to do it for the benefit of clients who we are really thrilled to represent, and you know, to support you guys in the work you're doing as well is an honor. So thanks for having me. I really appreciate it. Great.
We're happy to have you. We always learn something new. So definitely the takeaway today is call your lawyer early, because as expensive as you think it might be to do it right, it's way more expensive to get it wrong, particularly where your friends at the Department of Labor are involved, because those fines and penalties get out of hand super fast. I was amazed when the Pandora's box first opened, because of course that was not my world. And the first time I encountered that with a file, I was like, wow, that could have gotten ugly quick.
There's some real risk here, and I hope that our hour spent this morning was an hour well spent to help some of our attendees and clients manage that risk in a much easier way.
I appreciate it. As always, you are a pleasure. Thank you, Jackie, for all that you do. This has been quite a bit of fun. We'll be on next Tuesday with John Cipher, and he wants to know if you want to have more sales. So he's always trying to make us sell more. So
love it. Thanks.
All right. Thanks, ladies. Have a great weekend, everybody.
Have a great week.
Bye-bye.
Bye.